Okay. Hey there, GoPo students. I hope everybody's doing well. I hope everybody's staying safe, healthy, and mentally sharp, of course. We're heading down the home stretch here. We have the GoPo test in less than a month, ladies and gentlemen. So I've already posted some bureaucracy videos on there, and we're now going to head into the judicial branch. And to start off with the judicial branch, we are going to start that with our last primary document. Remember, we've studied many primary documents over the course of the year, from the Constitution to the Declaration of Independence, the letter from Birmingham jail, and then all the Federalist Papers. Federalist Paper number 51, dealing with checks and balances. Federalist Paper number 10, dealing with factions. And then Federalist Paper number 70, that stated the need for a strong executive. We are now going to dive into our last Federalist Paper, which is Federalist Paper 78, dealing with the judiciary branch, specifically why judicial independence is necessary, and terms of office for a judge should be different than regular elected officials. I'll be posting the typical document we use for primary document analysis on Google Classroom, along with Federalist Paper number 78. So feel free to have both of those open while you're watching this, and you can fill in the document as I'm talking, or if you want to read it, do it ahead of time, fill it in yourself, and then use this as a review to see if you got all the major highlight points of it. So here we go. I'm going to share my screen with you here. All right, and here we see our primary graphic source organizer. Remember, we are going to put this into our Google Drive folder where primary sources are, because organization is cool, organization is fun, organization saves time, and organization relieves stress. Okay, so Fed paper number 78 was written by Alexander Hamilton, ladies and gentlemen, and Hamilton in Federalist Paper number 78 basically addresses these two questions. Why shouldn't judges be elected? Every other top level official, say in the federal government, has to be elected. Members of the House have to be elected every 2 years. Members of the Senate have to be elected every 6 years. The president has to be elected every 4 years. Why should judges not have to be elected like everybody else? And then the second argument that he makes is why judges should have lifetime tenure. That is, they should serve on good behavior, is what it says in Article 3. And Hamilton's going to make the argument that we should not have judges, if they are going to be appointed by the president and then approved by the Senate, which is what he argues should be done. Why shouldn't judges have to be reappointed every so often, just like members of the House, members of the Senate, and the president have to be reelected? So that's what Federalist Paper number 78 is basically going to address, those two issues. Why judges shouldn't be elected, he's going to argue that. They should be appointed by the president and approved by the Senate. And then once that's there, Hamilton argues that they should be there for life or until on good behavior or retire. And so that's what we're going to address in this, okay? The main arguments that Hamilton makes, the main points in Federalist number 78, is that judges should be appointed by the president and then approved by the Senate, and then once they're there, serve for life. And the reason is he says that the judicial branch is the least tyrannical of the three branches. The three branches, the executive, legislative, and judicial branch, the judicial branch is the least threat to become tyranny over us, because Congress can make laws of which can have tyranny over us. The president gets to enforce those laws which has tyranny over us. And he says that the judicial branch is the least threat of that, okay? And the second argument he makes is that the sole purpose of the judicial branch is to overturn Congress and the president and preserve our liberties for when those two branches try to get beyond their power. Such, for example, as the judicial branch can overturn laws passed by Congress that are signed by the president. The judicial branch can overturn executive orders that are done by the president, treaties that are signed by the president and approved by the Senate. And so the argument he's making there is that the judicial branch is a preservation of liberty for us. And so the independence of those courts is essential. So for judges and the judicial branch to actually preserve our liberty and actually properly check the executive branch and the legislative branch, is they need to be independent from political pressure, independent from Congress, independent from even the people, because judges are not there to represent the people of the United States. I've heard that argument made before, is that our Supreme Court and federal judges are not representative of the people. That's not a good argument to make, because that's not what the judicial branch is supposed to be. The judicial branch is supposed to preserve the Constitution. The judicial branch is there to interpret the Constitution and preserve our liberties. And so the argument that the judicial branch should be representative of the people through elections, that's not the purpose of the judicial branch. That's the purpose of the legislative branch and the purpose of the executive branch, and that's why we vote him in, he's arguing. The judicial branch there is to make sure that our liberties are preserved and not taken over by a tyrannical government, such as laws being passed by Congress, executive orders from the president. And so in order for judges to have that independence, in order for the judicial branch to have that independence, we shouldn't have them be elected. Because if they're elected, instead of doing what the Constitution says they should do, judges are going to bow to the will of the people. Judges are going to make decisions of which will help them get reelected instead of actually making decisions based off constitutional interpretation. Okay? And that's also the argument that he makes for why they should have lifetime tenure. That is, if judges get appointed by the president and then confirmed by the Senate, which is what he argues that they should do, and that's what the Constitution says, if judges have to be reappointed from time to time, the same thing is going to happen to judges when they're making decisions. They're going to make decisions, and their judicial decision will be influenced by whether or not they're up for reappointment. And even if they're not up for reappointment, judges' decisions will be influenced by the fact that they know they'll have to be reappointed in the future. And they would be not as likely to make the decision based off what they think the Constitution is, and more likely to be influenced by, will this decision allow me to get reappointed by the president and reconfirmed by the Senate, not even knowing who the president or the composition of the Senate, what would be when their reappointment was up. And so these are the two main points that Hamilton argues of why we need judges to be appointed and confirmed, not elected, and then once there, serve lifetime tenure. Judges will be freed up from any kind of political pressure. Judges will be not limited by what the will of the people are, but judges will be able to make decisions based off what they think the proper interpretation of the Constitution is. Okay. Now, let me give you an example of where that would happen. President Trump has appointed two presidents to the Supreme Court since he's been in office, Justice Kavanaugh and Justice Gorsuch. Both Kavanaugh and Gorsuch have actually sided in a few cases with liberal justices since they've been in office. And Hamilton would argue, would they have been able to do that if they didn't have lifetime appointment or if they had to be elected by people in the future? That is, would Justice Kavanaugh or would Justice Gorsuch have sided with liberal justices on decisions, knowing that they might have to be reappointed in the future by a Republican president or a Republican Senate? Would they have made those decisions and sided with the liberal justices if they knew they had to be reelected by the people, right? And so judicial independence in lifetime appointments frees judges up to have the ability to make the decision based off what the Constitution says in their interpretation of the Constitution, not based off what political pressure gives them, okay? And they say that they can do that, and I'm sorry, by allowing them to do that, that also protects the minority. So he says the judicial branch is the minority's protection from the tyranny of the majority. That is, if the majority elects a legislative branch that starts passing laws to infringe upon the rights of minorities, the judicial branch has the independence to overturn those laws. Okay. And keep in mind, again, when I'm talking minority, I'm not talking ethnic minority or gender minority. I'm talking about numerical minorities. Therefore, if we get a majority of people that elect enough people to the House and the Senate that can pass laws, and the president is in line with those, and the president signs those laws, they could easily take away liberties from the minority. And he would argue in Federalist Paper No. 78 that judicial independence gives the Supreme Court the ability to protect minorities from having their liberties taken away by tyranny of the majority. And so those are the main reasons he argues in Fed 78. Okay. So the key connections we're looking down here that you need to fill in as we're doing this is we get lifetime appointments for judges. Okay. Judges are appointed by the president, then confirmed by the Senate, not by Congress. And once they're there, it says in the Constitution, as long as they're on good behavior, but we say those are lifetime appointments. So judges can serve as long as they want to serve. Judges can be impeached for illegal activity, but they cannot be removed for unpopular decisions. So the president may be very upset with the decisions that the Supreme Court hands down. Congress may be very upset with decisions that the Supreme Court hands down, but they cannot be removed from office for making unpopular decisions. That's the very purpose of judicial independence and lifetime appointments. Okay, they are freed up from political pressure. And so with that, we actually do see some judges that do stray from their political leanings once they actually do make it to the Supreme Court. Probably the most famous example of that would be a judge named David Souter. David Souter was appointed by President H.W. Bush back in the late 80s, early 90s. And President Bush appointed him because he thought he was a relatively moderate conservative to the Supreme Court, and he thought his nomination would be passed. But once David Souter was appointed to the Supreme Court, he then showed his true colors, and he was not a moderate conservative. He was actually a very liberal justice. But there was nothing that George Bush could do about it, because once judges are confirmed and once they're appointed and confirmed, they're there for life. Okay, so that's Fed paper number 78, ladies and gentlemen. That is a short video for today. I will be posting more videos about judicial branch. I'll have 2 more lectures coming on the judicial branch specifically that I'll be posting on YouTube. And we're going to cover a lot of topics about the judicial branch, the different layers of federal courts. The Supreme Court is where we're going to spend most of our time. And we're also going to cover things like judicial activism, judicial restraint, and how can we control a out of control Supreme Court. And then again, I'll also be posting videos about review for the AP test as well. So if you have any questions, please don't hesitate to email me, and take care, everybody. We'll talk to you soon.